County Councilwoman Monique Anderson-Walker, representing District 8, but certainly representing all of Prince George's County. I'm very interested in making sure that we all survive this COVID period and beyond. Whatever the challenges are, we want to make sure that we can still have a roof over our heads, we can eat, and we can survive with the least bit of stress possible. In recognizing that everything requires money. And this is a time that we're all challenged with money. We recognize that jobs have been, in some cases, limited. People have been restricted in income because of this challenging period. But we don't want people to lose their opportunity for housing. So this is set up so that people understand what their rights are, what you can do as a tenant to protect yourself, and what resources there are to direct those people who have tenants who have not paid as well, as to what pursuits they can take moving forward in order to be made whole as well, if that's going to be possible. One of the questions that we had with Community Legal Services of Prince George's County, we're very, very honored to have Ms. Kayla Williams here today, who is an attorney and who will be giving us direction and a presentation on evictions and proceedings. We're very excited about that, but one of the big concerns we had was, look, we are almost 7 months into this COVID period, and much of the funds for housing that were to be released to people has not been released. So when you're 2 months behind, it's challenging. You know, you have maybe one more month before action's taken when you're this far behind because you haven't gotten the funding that one expected to get through maybe the county or federal sources. It makes it stressful for everyone. Certainly the tenant, but also the property owner as well. So we're hoping to get clarity tonight, and so that we can all be a little bit more at ease moving forward through this. Before we begin, I just want to say, I hope you filled out your census. Originally, September 30th was to be the last day for census, but it was extended to October 5th. So if you haven't, please do. You need to be counted. You matter, you count. Mainly because each individual means, for each individual that's counted, that's $18,000 plus that we get from the federal government to go into services that can then help us through some of the challenges when we're in these challenging periods. But we will move forward. As I say, we need you counted. We also need you to make sure you vote. We need your vote counted for wherever you stand in this election. Vote, get out, it's important. Vote like your life counts on it, because it does. With that said, I want to just introduce my staff that's here, Gina Anderson-Ford, because she's someone who you will likely be reaching out to when you contact my office. Carla Cash, who's not on the call right now, but many of you know her because you've reached out to her for other reasons as a constituent service director. And I also have Hugo Cantu, who's on the line. Hopefully he will wave as well, so that you can become familiar with them should you have any questions. With that said, Ms. Williams, take it away.
Good evening, everyone. My name is Kayla Williams. I'm an attorney with Community Legal Services, and I specialize in housing cases. So I represent tenants who are facing eviction. Not only does our office do that, but we do foreclosure cases, family law, domestic violence, bankruptcy, pretty much any non-fee generating civil case that you can think of. Our specialty is we represent low-income tenants, and we are grant funded, and so that's why we have to report back to our grantors. So tonight I will be going over some of the eviction moratoriums that are currently in place. Although this presentation, it may seem a little tenant focused, I think it is pretty important for homeowners and landlords to know as well. And at the end of the presentation, I will also give resources that can be helpful to everyone. We want this presentation to be interactive, so if you have any questions, please submit them in the chat function, which should be at the bottom of your screen, okay? Feel free to interrupt me, or probably not interrupt so it's not too loudy, but if you can just put them in the chat, someone will make sure to review them.
Mm-hmm.
So I am going to share my screen. I created a PowerPoint presentation for everyone. So let me do that now. Oh, can you make me host again? Sorry, it says that it's disabled. Ms. Anderson-Ford, can you make me host? Is that possible? Thank you. Okay. Okay, here we are. Give me 1 second. All righty. All right, so forgive that formatting issue. So again, we will be discussing evictions during COVID-19. All right. Okay, so the court is currently in phase 5 of its reopening plan. And so we often get questions whether the court is open, whether it's closed. The court is open and it is hearing all types of cases. So phase 5 will officially begin October 5th. But as of right now, the court is hearing all landlord-tenant cases. So this will be a pretty substantive and dense presentation, but I will make sure that this PowerPoint is made available after the fact. So this is kind of a summary of some of the cases that I deal with, but that also you may all have encountered at some point. We'll be discussing rent escrow cases, tenant holding over cases, breach of lease cases, wrongful detainer actions, and what a warrant of restitution is. And this kind of just summarizes what each type of case is. Okay, and these are the 3 types of eviction moratoriums that we will be talking about tonight. The first and possibly most important is the CDC eviction moratorium. We're also going to be discussing Governor Hogan's order, which temporarily prohibits certain evictions due to a loss of income. And we'll also be talking about the Prince George's County Bill CB 16-2020 that was passed during COVID-19. So the first legislation that we'll talk about is the CDC eviction moratorium. So this order bans landlords from evicting tenants for non-payment of rent through December 31st. So essentially it appears that this legislation only applies to non-payment of rent cases. But what I need people to know, particularly tenants, is that in order for this moratorium to apply, you must print out and submit the CDC declaration form to your landlord. But make sure that you read it very carefully, and I'll also include the link after this slide. What you should know about the CDC declaration is it does not cancel rent. It does not make rent not owed. It simply means that it's delaying any eviction that could have taken place through December 31st. So technically your landlord could say, you know what, well, I'm not too concerned about eviction. I'm instead going to go to civil court and try to get a money judgment or garnish wages or something along those lines. So keep in mind that this does not stop rent from being owed. It simply delays the eviction process. So for the CDC moratorium, keep in mind that even if you give it to your landlord, they still may file a court complaint and you are still required to appear in court. And it's always to your best interest to appear in court, because that way you can advocate on behalf of yourself, but also you can hopefully get an attorney to assist you, whether that be with advice or with actual representation. Keep in mind also that unfortunately the CDC eviction moratorium only appears to apply to non-payment of rent cases. What that means is your landlord can still attempt to try to evict you on a different basis. So say, for example, if your landlord says, you know what, I'm not too concerned about the money, but I'm concerned that the tenant is breaching a lease term, or this person is in my home and they're not paying me any rent, or their lease term has expired and I want them out. So there are other grounds that your landlord may still be able to evict you on, even if you give them the CDC moratorium paperwork. Okay, so in terms of eligibility, as mentioned, I will provide a link to the form. It's a pretty lengthy piece of paperwork. It has a lot of information, so you want to read it very carefully. But the key takeaway is, in order to be eligible for the CDC moratorium, you want to make sure that you qualify and you meet these points. And this is all laid out in the CDC form. So to be covered, you have to basically say, under penalty of perjury, that you have tried all of your best efforts to obtain government assistance. You have to swear under oath that you have earned no more than $99,000 if you're filing your taxes individually, if you're not married, or if jointly filing, that you've made no more than $198,000 during the 2019 tax year, or you can show that you've received a stimulus check. You want to show that you have been unable to pay your rent due to a substantial loss of income, whether that be loss of hours, extraordinary medical expenses, you've been laid off, etc. That you're using your best efforts to pay whatever you can towards the rent. So technically, if you're not paying anything, your landlord may be able to argue that they're not attempting to pay anything, and that if the court did not delay an eviction, you would likely be homeless. So those are some of the qualifications that you would need to essentially say are correct in order to apply for the CDC eviction moratorium. So here's a link to access the declaration form. So if you do believe that you qualify, you can go to that link, you can print out the form, read it very carefully, and you can sign it. You want to make sure that you keep a copy for yourself and also give a copy to your landlord. And also, if you have to come to court, make sure that you bring a copy of the signed declaration form. I always advise tenants that if you do give it to your landlord, to try to give it in a way that shows proof that you have actually given it to them. So perhaps by email, so that you have a written record of it, or you can do by certified mail. You can do in person too, whatever way is easier, but I just prefer everything to be in writing and have a record. Okay, so next we will talk about Governor Hogan's order temporarily prohibiting evictions. So this came out, I believe, in March or April. And essentially it says that the court, so as long as there's a state of emergency that's declared by Governor Hogan, a court is prohibited from ordering any eviction if a tenant can show through verifiable means that their failure to pay rent is a result of substantial loss of income. Keep in mind though, when I say that it prohibits an eviction, this particular order only applies to non-payment of rent and breach of lease cases. So say, for example, you've lost your job because you work for a restaurant and the amount of customers have been reduced, or if your hours have been reduced, if you can no longer afford childcare, so as a result you've had to quit your job, or if you've gotten sick or cared for a loved one and as a result you've lost your job or lost income. Anything along those lines can be used in court if a landlord files a failure to pay rent or breach of lease case against you. Keep in mind though that this order provides that a tenant must provide some type of verifiable means that they actually have suffered substantial loss of income. So meaning that you want to try to come to court with either pay stubs showing that you're not getting paid, or if you have like a letter from your employer stating that you've been laid off or your hours have been reduced, that would be helpful. Okay, so the next bill that we will talk about is the Prince George's County Council bill. It's called CB 16-2020. And I believe that this bill was at some point modified, the language of the bill was modified. But it essentially says that a landlord cannot or shall not increase rent for a tenant who can show that they've suffered substantial loss of income. And this piece of the bill is effective as long as there's a state of emergency and within 90 days after that state of emergency is lifted. So keep in mind that in terms of the rent increases, a tenant must go to their landlord and show that they've suffered a substantial loss of income in order for their landlord to not be able to increase their rent. Otherwise, I think there's different municipalities that have some rent increase statutes, but generally a landlord can increase rent. Also, this bill also states that a landlord cannot impose late fees or penalties for any tenant if the late fees or penalties would take effect during the state of emergency. So this is a little different from the first section in that it says that late fees and penalties cannot be charged for any tenant whatsoever as long as there's a state of emergency. So just keep that in mind. And I think someone had a question earlier about some attorney's fees that the landlord was charging. Keep in mind that those often come up in court, but arguably it should not be considered rent. So I have an issue with it being on the ledger, but sometimes that's just something we have to argue in court. But that could be considered a penalty as a result of paying your rent late. Okay, so I want you all to take away that the evictions in Maryland must always be done through the court. So non-judicial evictions in Maryland are always illegal. They have been illegal. They are currently still illegal. So in order to evict a tenant, a landlord must first go through the court and file some type of paperwork. This is just the particular statute in case you're interested. But I've also just created a little kind of like a graphic to kind of lay it out and make it a little bit more simpler. So essentially, this is how the process works. And also keep in mind that all of the cases that I'm talking about, they deal with possession of the property. So we're not talking about like money judgments and if your landlord is suing you for back rent. This is if your landlord is suing you for possession or they're trying to have you evicted. So essentially, the landlord would be required to file some type of complaint with the court. After they file that complaint with the court, the tenant would then be summoned to appear at a court hearing. And that's where you would have the opportunity to raise any defenses that you may have, and vice versa, landlord, you would have the opportunity to raise any defenses that you have or, defend yourself. Next, the landlord would be required to obtain a judgment for possession and a warrant of restitution. So judgment essentially it's the opposite of a money judgment. So you're not necessarily concerned about the money, you're more so concerned about possession. But the piece of paper that actually allows the sheriff to act on that judgment is called a warrant of restitution. So a landlord must also obtain a warrant in addition to a judgment. And then once that warrant and judgment are obtained, the landlord must then contact the sheriff's office and an eviction is scheduled. And the sheriff can then act on that warrant. So just some examples of what can be considered a non-judicial eviction. Say, for example, if your landlord decided to turn off your electricity or turn off your cable or any type of service, turn off your water, that can be considered a constructive eviction. Or if your landlord attempts to change the locks, or if they actually physically remove your belongings without having a court order. These can be considered illegal evictions or illegal constructive evictions, and they could be penalized through a civil suit in which the tenant may have the opportunity to sue for damages. And again, it just says even if the landlord obtains a judgment for possession, he still must ask for a warrant of restitution and wait for the sheriff to act on that. So what to do if you are illegally evicted? So you can always file a complaint with the Maryland Attorney General's office. And the Maryland Attorney General's office is actually a really good resource outside of just eviction matters. They have a mediation service. So if a landlord and a tenant are ever disputing about like an amount owed or they can't reach an agreement, they're a really good resource in trying to just come to an agreement that works for both parties. So I'm a big advocate of the Maryland Attorney General's office. But also there is a civil suit. There is an option to file a civil suit. Okay, so now we're going to move on to some of the different types of cases that a tenant may be summoned to appear in court or a landlord may decide that they need to file. This is really good information because I think a lot of these things, there's a lot of legalese there's a lot of legalese involved. So I just tried to kind of summarize it in a very simple way. So we'll be talking about Ferry To Pay Rent cases. That's where a landlord is just alleging that a tenant owes rent. And as a result, they want possession of the property. We'll be talking about tenant holding over cases, and that's when the landlord alleges that a lease term has ended and that they've given the tenant notice to vacate, but the tenant remains there, and as a result, the landlord wants the property back for whatever reason. We'll also talk about wrongful detainer actions. That's when a homeowner, we're not talking about landlords, but specifically a homeowner believes that there's an occupant in their home who has no legal right to be there, and as a result, they want this occupant to leave or to be evicted. We won't really talk about rent escrow cases tonight. I don't think we have enough time, but I will give you a summary, and if you have questions, let me know. Essentially, with the rent escrow case, it's when a tenant is alleging that there are significant defects in their property that the landlord is refusing to fix, or that they've given them notice of, but nothing has been done, and that pose a threat to their health or safety. And as a result, they would like to pay their rent to the court as opposed to the landlord and have the court order the landlord to fix whatever issues are going on. And lastly, we'll talk about breach of lease cases, and that's when a landlord alleges that a tenant has violated a term of the lease, and as a result, they want the tenant to have to leave. Okay, so in terms of Ferry To Pay Rent cases, again, this is when a landlord seeks possession of rented property from a tenant who has not paid their rent. This complaint can be filed by landlord or the landlord's agent or by the landlord's attorney. These complaints often can include late fees plus additional rent. Additional rent is kind of like a legal term, but oftentimes a tenant will say, hey, I'm being charged with things that are not considered rent, like say, for example, parking fees or trash fees, things like that. Sometimes a landlord will attempt to collect those in rent court. And so you want to pay attention to your lease and see whether or not your lease deems those things to be additional rent. And again, keep in mind that the cases that I'm talking about tonight, these are going to be where a tenant is seeking, these are going to be focused on the goal of them from a landlord's perspective is to obtain a judgment for possession, i.e. an eviction. So we're not talking about money judgments where that involves like wage garnishment or civil suit collections. So we're simply talking about eviction cases. Okay, so this is an example of a Ferry To Pay Rent complaint. This is what it may look like. And I just kind of tried to circle some of the areas where we often kind of raise as a defense in terms of Ferry To Pay Rent cases. So essentially, it has to be filled out completely and accurately. It needs to list all of the tenants on the property. It needs to have the landlord's information. It needs to have the tenant's address, whether or not the tenant or whether or not the landlord has a rental license. We'll talk about that in a few. Whether or not the landlord has a lead paint license or whether it's required. Whether the tenant receives subsidized housing. And we really want to know exactly what months and what dates and how much rent the landlord is asking for. These all become relevant in court. Okay, and so in terms of the rental license, in Prince George's County, a landlord is required to obtain a rental license in order to rent property. And I'm talking specifically about residential property. So the purpose of having a rental license is before a landlord can rent out property, the county wants to make sure that this property is safe and free from serious defects. So in order to do that, they have to inspect the property. And if the property meets their code, that's when they'll give them a rental license or the license to rent the property. The exception to that though, a landlord is not required to obtain a rental license if the landlord is related to the tenant. So if it's their parent, their child, their sibling, grandchild, or in-law. Or if the landlord is an active member of the U.S. Armed Forces, so if they're in the military, and that's where they maintain their permanent residence, or if the landlord has been relocated for unemployment and maintains that property as their permanent residence. Additionally, in Prince George's County, the courts really want they want landlords to bring a copy of their current rental license to court. So that's pretty important. So if you are a landlord, just make sure to not only fill out the complaint, including your rental license number, but also make sure to bring a copy of your complaint or your license to court. Before the county issues a permanent rental license, they will first, oftentimes they would first provide the landlord with a temporary license. Essentially, a temporary license is when a landlord pays a fee and an inspection hasn't necessarily been done. But oftentimes the court will still find that sufficient to proceed in a landlord-tenant case. So in terms of an MDE case or an MDE license, essentially what that is if your rental property was built before 1978, you have to certify whether or not it has been affected by lead paint. So essentially, if your property was built before 1978, you have to go to the Department of Environment and obtain a lead paint inspection, and they just want to make sure that there is no lead paint existing. If your property is built after 1978, you don't have to worry about that. Keep in mind that if you change tenants, you'll just have to keep getting that lead paint inspection if your property was built before 1978. So there are certain defenses to a Ferry to Pay Rent complaint. Of course, if you are dealing with a substantial loss of income, or if you've given your landlord the CDC declaration form, those are arguably going to be defenses that you can raise in court. But in addition to that, if the complaint is incomplete, or if it's not signed, if the amount of rent requested on the complaint is incorrect, if it doesn't indicate what amount and what time frame the landlord is asking for rent, if the tenant's property isn't listed, if there's no witness available, it's important that if you are filing a complaint with the court, or if you're a tenant who's been summoned to appear in court, you want to make sure that you have any witnesses that you may need available, preferably on the day of your hearing, because if a hearing is needed, sometimes you can't allow, or sometimes essentially you have to ensure that you are the proper party to testify. Also keep in mind that late fees in Prince George's County cannot be more than 5% of the rent. So although late fees aren't technically allowed now during the pandemic, keep in mind that generally the Prince George's County Code does prohibit anything more than 5%. Okay, so even if a landlord does file a Ferry to Pay Rent complaint against you, and even if that landlord is successful, a tenant still has the right to redeem the property, meaning that if they can pay whatever amount the court determines is owed before a sheriff comes to do the eviction, that means they get to stay in the property. And this usually works best for tenants and landlords, because oftentimes landlords don't want to evict a tenant. It's just they need the money for whatever reason. Of course, you're under contract to pay the rent as well. The only exception to that, though, is if a tenant has obtained 3 or more judgments for possessions within the past 12 months, a landlord can ask that the court, what they call, foreclose the tenant's right to redeem, meaning that right to pay and stay is no longer available to them. So keep in mind, generally, if you get a landlord-tenant judgment, you can pay it and stay in the property. However, after 3 or more judgments, the landlord can then say, you know what, we've obtained 3 or more judgments within the past 12 months. This is a habit. We no longer want them to be able to pay to stay, and that technically means that you can pay a rent and the landlord can still evict you. So just keep that in mind. Okay, so next we will talk about tenant holding over cases. So this is a case where a landlord or homeowner is alleging that a tenant is staying beyond the terms of their original lease. So essentially it requires that a landlord first it requires that there be some type of lease, whether that be written with a definite lease term or whether that be oral. Maryland does recognize oral leases. They're not really preferred because it's really hard to prove the terms of the lease, but Maryland does recognize them. And if you are in an oral tenancy, you're going to be considered a month-to-month tenant. And usually with month-to-month tenancies, either party is required to give at least 30 days notice in order to terminate that month-to-month tenancy. So in order to prevail on a tenant holding over case, a landlord must show that there is a valid lease and that that term has expired. So say, for example, your lease ended in August. Your landlord would have to show that your lease, if it's September, obviously it ended in August. Just wants to know that that lease term has expired. But additionally, the court wants to make sure that the tenant that the landlord has given the tenant at least 30 days written notice to vacate before filing any type of court action. And then also, I would just say refer to your lease, because sometimes that notice term is more than 30 days. It could be 60 days. So just refer back to your lease terms. The court needs to know that the tenant is still in the property. Keep in mind that if you were filing a complaint for a judgment for possession, once the tenant vacates and removes all their belongings, technically you've regained possession of that property. So if a tenant is no longer living there, then technically you can't evict them. So in order to prove this case, the court just wants to make sure that the tenant is still living there. And so essentially, before filing a tenant holding over case, your lease has to expire. The landlord has to give written notice to vacate and also let that notice period expire before filing a complaint for tenant holding over. Okay, the next type of case is a wrongful detainer case. So this is where a homeowner, not a landlord, but a homeowner is alleging that there's someone who lives in their property who does not have a legal right to be there, meaning this person doesn't pay rent, they never had a lease agreement, they don't own the home, they weren't granted possession of the home through a court order, they're merely a guest, and the homeowner now wants them to leave. So that would be the type of action that the landlord would want to file. We oftentimes, I think people will get wrongful detainer and tenant holding over cases confused, but just keep in mind that a tenant holding over case actually involves a tenant. So this person is paying rent, a lease agreement was created, versus a wrongful detainer. It means that we essentially just had an agreement that you wouldn't pay rent, that I would just allow you to stay at my house, rent free. That's kind of what a wrongful detainer entails. Okay, next we have breach of lease cases. So this is where a landlord is alleging that there's a lease agreement, that a tenant has breached a specific term of that lease. The landlord has given the tenant some type of notice, some type of written notice to vacate, generally at least 30 days, but if the landlord's alleging that it's some type of significant breach that poses a threat to their health or safety, they only have to give 14 days. That notice period must expire before filing the suit. And also, for a breach of lease case, the landlord must show that the breach was substantial and that it warrants an eviction. Okay, and this is actually the end of my presentation. Of course, I'm happy to answer any questions you have, but here's just a list of helpful resources. If you need our assistance, our information's right here. It's clspgc.org, but you're welcome to call us. MD Lab, that's Maryland Legal Aid. They provide civil legal services. They're just like us for the most part, but they handle a little bit more complex civil litigation. You can also contact the Maryland Courts website. They have pretty much all of the forms that you may need. So if you did want to file something, you can go to their website, print it out, fill it out, and then submit it to the court. peopleslaw.org is a great resource for everyone. I refer a lot of landlords there, but I also refer a lot of tenants there. So it's part of the Maryland Courts, and I believe self-help initiative, but essentially they kind of break down the statutes into very simple terms, and they direct you directly to the statute as well. So if you ever had a legal question and wanted to just do some research on your own, People's Law Library is a great resource. evictionlab.org, that is a great nationwide website where you can see what eviction moratoriums and protections exist in your local jurisdiction, or if you wanted to look outside of your jurisdiction, you can also look that up as well. And lastly, the Maryland Courts Self-Help Center is also a very good resource. We refer a lot of landlords to the Maryland Court website or Maryland Court Self-Help Center, but also tenants as well. They don't provide a representation. However, they do provide free brief legal advice and help filling out forms. So if you wanted to file your own lawsuit, or if you wanted to file a complaint, but you just wanted an attorney to kind of go over it with you and tell you how to prepare yourself to appear in court, they are a really good resource. Whereas our office primarily provides advice, but also representation at court hearings. Okay, so I will stop